You spent years in school learning the art and science of practicing medicine. You spent years learning how to protect yourself from lawsuits, and you've taken every precaution possible to protect your patients. Now, your hard work has been rewarded in the form of an offer of employment, a contract. Congratulations. Spend the time now to protect yourself. You deserve it. The employment contract defines the conditions under which you will work, usually for a term of years. You owe it to yourself to make sure those years result in your personal and professional satisfaction. Remember, an employment contract is one of the most important financial decisions you can make. Misunderstandings can result in seriously painful consequences. To assure the best result, you must spend some time with a professional to understand the terms and conditions of the employment contract which has been offered to you. And because physician contracts are unique, it is important to select an attorney with healthcare experience. A contract's legal terminology, such as restrictive covenant and assignability, can be confusing, and some important contract provisions, if not understood, can lead to problems in the future. Other provisions may need to be negotiated. Some physicians believe they have little choice but to accept the contract as it is originally presented to them. Others make the mistake of thinking everything is negotiable. The truth lies somewhere in between and will vary from case to case. Let's touch on some important considerations you will have to make. Salary and incentive pay. It is very important for a physician to fully understand the compensation formula the group will use to calculate salary and incentive pay. Sometimes those formulas are confusing and have hidden factors to look out for. I can help you cut through the confusion and avoid dangerous pitfalls. A flat rate annual salary is a thing of the past. Today, salary formulas are often combined with incentive formulas. They are sometimes based on productivity, the number of patients seen, or even a percentage of the physician group's profits. Most of the incentives that will be tied to productivity are defined in terms of RVUs, charges, net or gross collections and calculations. Sometimes other performance variables are added to reflect patient satisfaction, utilization, quality improvement measures, especially for hospitalists, etc. Too many incentive criteria makes for confusion and frustration on the part of physicians. It is important to analyze which of the incentive variables may, in part, be beyond the physician's control. For example, net collections are influenced by the effectiveness of the group's billings and collection staff. So how good are they? Will they be obstacles to obtaining the salary you ultimately expect? Will you have access to the books and records to verify the checks you receive are accurate? Call me now for a thorough contract review. Young physicians will do well to consult a financial advisor who works with physicians to consider the tax consequences of compensation plans, special insurance needs for physicians, and estate planning. I work with such professionals, and I can refer you to them without charge as an added service. Duties and requirements. Your physician contract agreement may state that you are a full-time employee, but what does that specifically mean? Are you expected to attend to administrative duties such as bookkeeping and collections? Will you have teaching or training responsibilities? Who will work under you and who will you report to? Will you be saddled with all of the after-hour calls to the practice? Every physician contract should clearly state this information. The length of the work week should be spelled out. You should know approximately how many patients you will be expected to see. In certain specialties, it's extremely important to find out the approximate number and type of procedures you will be expected to perform. Similarly, a hospitalist will want to learn as much as possible about the group's contract to provide hospitalist services, since this agreement will largely determine the physician's duties and objectives. How will your performance be reviewed? Will you have an opportunity to respond? These and other questions are raised and addressed in an appropriate physician contract review. Restrictive covenants and non-solicitation clauses. I am familiar with the case law which informs when a restrictive covenant can be enforced and when they may not. Non-competition agreements, also known as restrictive covenants, apply when the employer-employee relationship comes to an end. The clauses seek to protect the employer from the negative competitive effect which may be felt when the employee goes to work for a competing practice or hospital. These clauses are some of the most important, yet least understood aspects of a physician employment contract. These clauses seek to prohibit the physician from practicing medicine for a specified period of time in a specific geographical area. What is reasonable and therefore enforceable in one state may not be in another. Further, the clauses must strike a fine line between protecting competition and preserving for the physician an opportunity to make a living without having to move to another state. What happens if a patient learns the physician has left the practice but seeks out the physician's services? May the physician provide those services? What remedies would be available to an employer who learns that a former employee is in violation of the restrictive covenant clause? Physicians who consider these questions are being served well by their counsel retain to review their physician employment contracts. Termination. Termination clauses in a contract usually include both termination without cause and termination for cause. The manner in which the contract terminates will usually have a financial impact on the employee. The physician contract should spell out under what circumstances the employee can be terminated for cause or without cause. Typically, termination for cause may be allowed where the physician poses a health threat to patients or others, the loss or suspension of their license, felony conviction, or other event which causes harm to the employer. Often, contracts provide that if an employer wants to terminate a physician, the employer is obligated to give the physician notice of the issue which is causing the termination and a limited period of time for the physician to cure the issue being raised. In conclusion, you owe it to yourself to consult an attorney to assure that these and other issues are adequately addressed and understood in your employment contract. Think of it as inexpensive insurance, designed to assure that the terms of your employment are what you expect. Failure to seek the advice of a healthcare professional could result in financial difficulties and a poor quality of life. Call me now and arrange for a thorough review of your physician employment contract.